here today. Okay. Thank you all for joining us this afternoon. My name is Katie Anderson. I am the CEO here at Aperion, and so happy to have you with us today. As I noted, we are going to be recording today's session so we can use this on our YouTube channel. So feel free to keep your cameras off and muted during the session, but I will be taking questions from the chat. So if you have anything that comes up during my presentation, feel free to put that into the chat and I'll try and cover those questions as we're going through the presentation. And I will also leave time at the end if you have any specific questions that you would like to ask. So thank you so much for joining us today. We are going to be covering our board fundamentals. This is really the basic foundation of you have been elected to the board or you're serving on the board, and what are some of the key things that you need to know about that engagement with your community. So we're going to be covering some association basics. We're going to go through some brief conversations about the operations for your community, some tips for running an effective community and your role on the board and how that kind of interplays. And then we're going to go over a few key legal protections that we find are really important for boards to understand. We may share some tricky or scary obligations, and so we want to make sure that we go through also the things that protect you legally, both in the statute and in your governing documents. So, association basics, understanding the foundation of what a community association is and how they function. The three key functions for communities and sort of what they play, the role in your individual culture for your community really is three key functions. Your role in executing for the association is community. What's the culture of your organization? What are the expectations? And what are the shared standards? Most of this comes from the established governing documents that are put together before anybody even purchases a home. But this sets the foundation for each community. Within that, you're going to have your business functions, which are going to be your budgets, your contracts, the assets that you own as an organization. And then you're going to have your government function, which is your rulemaking, your enforcement, and sort of your duties as a board. Most of what we're going to encounter in your role as a board member is going to fit into one of these three functions. You will hear us use, both myself as well as your community manager, your assistant community manager, anybody on our team. These are words that you probably will hear us use pretty frequently. There are a few different interchangeable terms for what we call the CC&Rs. Your community may also be called a declaration, may be called covenants and restrictions. There can be varying combination of these words, but your CC&Rs are essentially the documents that govern your corporation. They establish those shared expectations. They establish what you agree to when you first purchase a home or you purchase a condo or you purchase into a community. And so those CC&Rs can be a bit interchangeable, but those are essentially your governing documents. You'll hear us use assessments pretty frequently, and you will generally never hear us use the word dues. Dues are voluntary. Assessments or something that are paid as an obligation. So your assessments is going to be the obligation that your owners have in order to fund the operations for the corporation. You'll hear us talk about fiduciary duty. A lot of times you'll hear owners potentially use this, and a lot of times it'll be thrown around in an attempt for them to get you to do what they would prefer for you to do. Sometimes isn't always what you should do or can do, but it's your obligation to act in the best interest of the association. Quorum is a pretty important thing for community association. This is the minimum number of members that are needed to conduct business. And this can be both for a board meeting. It can also be for an owner's meeting. And we're not going to go too deep in the distinction around those meetings today, but we do have other trainings available on our YouTube channel that talk about annual meetings and effectiveness of running board meetings. And so we won't go into those too deeply, but just understand quorum is the minimum number of people that you need to conduct a meeting. You're also going to hear us talk about reserve studies and common areas. So your reserve studies essentially are the money that you're collecting in order to take care of your common area. And your common area is the shared property that is established in your governing documents that your corporation owns. What are those amenities? What are those things that you're obligated to take care of? So within the framework of community association in Oregon, the most common community association is going to be a planned community. And a planned community is the owners own the lot or the unit, because you can have attached product that is a planned community, and you have commonly maintained common area. So this could look like a single family community with a park. Could look like a townhome community that are essentially zero lot line homes, and you have common elements, but you're not responsible for the exterior of the dwelling. So generally, if you have an attached product, for it to be a planned community, the individual owner has responsibility for the windows, the siding, the roofs, those pieces, and then you have a shared amenities agreement as to how the attached portion of the building will be treated between the two owners. But you don't have a corporate obligation for the association to maintain those things. So planned communities can look differently, but they have a common thread that the homeowner owns their lot and owns the unit, and they have a shared common area that the community is responsible for. The second most kind of common in Oregon is going to be a condominium. And this is the owner holds title to the airspace, essentially the dwelling within the inner walls, and then has an undivided interest in the common area. And the common area for condominium can be the outer shell of the building as well as amenities throughout the property. So it could be a pool, it could be a park, tennis courts, those types of things, as well as that outer shell of the building that the association is responsible to maintain. So you got planned community, you got a condominium, and there's a few other types of community associations. They're not as common in Oregon as in other states, but we like to touch on them so that you're aware. Cooperatives, the members own shares in the corporation that owns the property, so they don't hold physical title to the property. We don't have a lot of these. You see these more common in larger cities, very popular in New York and over on the East Coast. Master plan communities, we do have a handful of these master plan communities that have been developed throughout Oregon. And generally, the master association is established when you've got sort of shared property or shared assets that multiple associations are contributing to. And so you would have a master that might oversee roads and amenities, and then you've got subs underneath there that may all look a little different, may have different types of maintenance responsibilities or things that make them unique to one another. And so these masters are generally made up of multiple corporate entities. The master usually oversees some shared property, and then the subs will generally be responsible for sort of their buildings or their assets or things that are unique to that corporation. Mixed use development, we do have a handful of these, and this it combines multiple different types of land use designations. You're generally going to have like a residential, a commercial, and retail. Not generally would you see a mixed use development with like industrial or that type of usage, because you wouldn't want it to conflict with residential usage. But you're generally going to see in mixed use where there are multiple different styles of living. And then you would have designations as to sort of who's contributing to what. 55 and older communities, we do not have a lot of these in Oregon. They're not as popular, but these are generally age-restricted communities, and they could be condominiums or planned communities, but they generally have within their governance structure a restriction on the age of who can live in those dwellings. So how is an association formed? You've got different types of land classifications and different styles of communities that can be established. How are associations formed? So association is initially created by developer owns a piece of land, has a vision for how that land is going to be developed. They will work with the city or the county or the municipality, and they will establish sort of a legal framework that will set that community up, both in how the community is going to look, but also how the community is going to be governed. And this is done initially by the developer when they establish those governing documents. And the governing documents that are established initially by the developer start with the plat. And that plat forms what the community is going to look like, and it actually creates the units that are ultimately going to be sold, the units or the lots. And so that plat, whether you're a condominium or your planned community, is initially developed by the developer, and that plat lays out how many lots or how many units are going to be sold in the community, what the overall boundaries of that community look like. So the plat will include number of lots, it'll include common area, who's responsible for that common area, it'll include easements, location of utilities. It'll also include some maintenance responsibilities. So, for example, you could have a plat that lays out an easement for the city and whether the city is going to maintain that or whether the association has an obligation. So there's quite a bit of important information that initially establishes the community. And that plat is the first recorded piece of information that sets that corporation's foundation. So the plat within the hierarchy of how we enforce documents, that plat is sort of at the top of it. And then you're going to have your federal and state laws. We don't have a lot of federal laws, but we do have a handful that the community associations are responsible for. So you have the OTARD regulation, which is regarding satellite dishes. You can't prevent somebody from placing a satellite dish, but we can put reasonable restrictions. The flag regulations, again, you can't prevent somebody from flying an American flag, but we can put reasonable restrictions. So placement, size, maintenance. This doesn't protect for any other flag besides an American flag. So this doesn't protect college flags or football teams, those types of things, other political flags. It protects the American flag. And so that can sometimes come up occasionally on really what's the right that's protected. And then we have fair housing regulations that we're responsible to abide by and fair debt collection. So both of those kind of overarching over our industry that we have to abide by. Most of that is going to be done either by your attorney or through our team. We don't expect our board members to be experts on any of those things, but it's important to know kind of at a federal level, those are really the regulations that would impact you. And then at state level, we have three chapters within the Oregon statute that apply to community associations. You have Chapter 94, which is the Planned Community Act, Chapter 100, which is the Condominium Act, and then Chapter 65, which is the Nonprofit Code. And those three, so if you're a planned community, you're going to be subject to Chapter 94. If you are a condominium, you're going to be Chapter 100. Both are applicable to Chapter 65, which is the Nonprofit Code. When your developer is establishing your community, the documents that are developed at that point in time are going to comply with the rules that existed at the time the developer is drafting those regulations. So, sometimes boards will feel like, well, we got to go back and review the governing documents. Do we need to amend these things? Those are established at the time when the rules exist. There are occasions within the chapter 94 and 100 that those regulations get amended. And usually when those amendments or changes to statute go into play, the language will be really specific on if it's overriding what your documents say or if it's coming alongside them and amending the language if your documents are silent. And so state law can be really helpful for filling in the gaps that might not be in your CC&Rs. And there may be things that your documents are silent on that you can seek advice there. But when we look at the overall hierarchy, the federal and the state laws are going to supersede your CC&Rs and your governing documents. And so your plat's the first thing that gets recorded. It takes into account the state and federal laws that exist at the time. And then your declaration or your CC&Rs is the second piece that gets created along with your bylaws. Generally, both of those documents are kind of recorded all at the same time. So the plat may be recorded, a bit of time prior to when they're establishing the community. And then generally right before the first sale occurs, you'll have your CC&Rs and your bylaws that get recorded. And those are the recorded documents. The other documents that you see noted on here with rules and regulations, those are generally unrecorded. Those are things that you have the power in your governing documents to establish. It's generally done by your board of directors. It can also be done by architecture review because there are some documents that allow for your architecture review committee to create design guidelines. So occasionally that can be done by a committee. But those are documents that aren't generally recorded. They have the ability to evolve over time as needed. And as a community shifts, those rules and regulations are going to fill in the gap for any specificity that may not exist in your CC&Rs. So general example of this can be your collections resolution, your compliance process, how many letters are you sending? What's the frequency that you're sending those letters? What is the penalties and fines if they choose not to comply? All of those types of really specific provisions don't generally exist within the declaration and the bylaws. Those are generally rules and policies that the board has the power to establish. And those can evolve over time as laws change or your community changes or things evolve for your community. And so those don't become recorded documents because they're easy to then modify, adopt, and notice your community of those changes. So when we talk about your role as a board member, you're going to hear us talk about a couple of different areas of obligation. What are you as a board member responsible to do? What are your committees and your owners responsible to do? And then how do we come alongside that as your management company to help you accomplish those things? And so within that framework of governing documents, when we talk about governing documents, we talk about both your CC&Rs, your bylaws, and your articles of incorporation. And your articles of incorporation really is a kind of single page document that sets the name of your organization, and that usually goes in tandem with your CC&Rs. So within the framework of those governing documents, your governing documents are going to provide a list of things that the board has a responsibility to do. You're also going to have things within the state statute that you have an obligation to do. So, for example, you have an obligation to hold open meetings. You have an obligation to, within your governing documents, to assess your owners for the maintenance of the common area. You have an obligation to make sure that you are ensuring all owners are paying their fair share of those expenses. So within those documents, there's a whole host of things that you sort of have the obligations to carry out. And we're going to talk about that a little bit later when we kind of talk about roles and expectations. But when we refer to those things, these are the documents we're pulling them from. We're not sort of making up this arbitrary list. We're pulling those items directly from your governing documents. And a lot of times when a problem comes up, that's the source you're going to go back to. You're going to go back to what do the governing documents say that we're responsible to do. So you have an owner come to the board and say, hey, we would like the board to install a new play structure on this section of land. The place you're going to want to start is, does the board have the ability to make that decision? Can we, within the governing document structure, assess the owners for that? Is that something that we have the money to do? Is it something we have the obligation to do? And so these documents sort of become the foundation of information for the board as you navigate things that come up. Frequently boards will be asked to relieve late fees or abate a fee. Your governing documents are going to provide sort of a bit of a framework for the board as you navigate things like that come up. And again, the state statutes are going to help to fill in the gaps. And depending on when your community was developed, if your community was developed back in the 80s, there may be a lot of things within your governing documents that don't exist, right? It might not talk about open meetings that came into law in the early 2000s. It may not talk about online voting or how you navigate electronic communication. Those are all things that came later in the 2000s that if your community was developed some time ago, then it may not be within your documents, but you can lean on the state statutes. So you don't have to feel like you have to go back and amend your documents because the two can sort of work in tandem together. And then, fair housing, ADA, those are things that you kind of keep in mind. They're not things that as a board you're going to encounter frequently. Most of that's going to be done within your framework of the experts and the individuals that you bring in to kind of assist on various things. We don't need our board members to be fair housing experts. We help train our staff on those types of things. And if you get into a sticky situation with an owner, that's when we're going to pull the lawyers in to make sure that we're not going sideways on any of those requirements. And then other sources of obligation are going to be your contractual obligations, your vendor agreements, your management contracts, your insurance. What does your insurance say that you have to maintain, report, communicate? All those are going to be things within the framework of how you function as a corporation that the board should be familiar with. So within those sources of obligation, you're going to have the board's obligations. And these generally are going to be under the section either in your CC&Rs or your bylaws that are going to talk about board power. And this essentially lays out what is the board responsible to do. Some key important words to always look at is like shall or may, should, when you're interpreting those documents, something that says, the board should make sure that it has insurance. That's not really an optional thing. You have to make sure you have insurance. But your documents may say the board may pass a special assessment. And so those are going to be things within the nuances of the provisions that are in your documents that are going to lay out things that the board must do or that the board can do and that you have some flexibility for. But this is kind of a condensed and generalized version of what most documents are going to lay out that a board has an obligation to do. You are established as a community association because there's some shared responsibility in an asset, either in the building, roads, common area. And so the establishment of a community association is sort of rooted in this foundation that you have something to maintain and that the governing documents provide you a structure in order to do that. And so you're maintaining, repairing, replacing that common area or that common element. And in order to do that, these are the obligations that it lays out that are going to help you do that. You're going to have provisions on managing the finances. How are we adopting budgets? How are we assessing owners? What happens when the owners are late? How often are we having to have meetings? What does that look like for board meetings versus owners meetings? I mentioned earlier, quorum. Each of those meetings are going to have a minimum number of people that have to be there. So if you have a 5-member board, generally your quorum is going to mean that you need to have at least 3 board members there in order to conduct that business. And it's important that the board have kind of a foundational understanding of this. If we're your management company, we're going to be helping to carry out quite a bit of this, right? We're going to make sure that proper notice is sent to your owners on meetings. We're going to help you maintain your meeting minutes, make sure that those get approved and are properly held in your records. So a lot of these things are things that we will help assist with, but there's this core foundation within your governing documents that establishes these obligations. You have a responsibility to enforce the governing documents. This is probably the hardest part of being a board member. This is probably the area that we have the most conflict arise for communities, and it's probably the most uncomfortable part of being a board member. You don't want to take action against a fellow neighbor. That's really tricky and hard. And especially when something arises that an individual disagrees with, right? We're telling people how they may or may not go about residing in their home. And sometimes that doesn't go over well, right? You dictate style and aesthetic in a community, and that can conflict or disagree with somebody. And so it is important to understand that you do have a responsibility as a board member to enforce the governing documents. We can't just say, well, that doesn't seem important, so we're not going to do that. That's always a really tricky thing. If your governing documents contain something that, the community sort of evolved beyond, then that may be a section that you want to consider amending or sending out for an amendment vote for your community instead of just ignoring it, as that can create some other unintended consequences. You'll have responsibility within your governing documents to maintain insurance on the assets that you own. So if you own a building, you got to carry property coverage, but your governing documents are going to establish what that minimum responsibility for insurance coverage looks like. And most governing documents are going to maintain provisions that say that the board of directors has an obligation to act in the best interest of the community. And this sort of ties in also to the nonprofit code, which talks about your role as a board member. And we're going to talk about that later on in the presentation when we talk about the protections that exist in the nonprofit code. But it's challenging as a board member to remember that you have an obligation to the whole corporation and community and not necessarily one individual. And those things can be at odds sometimes. And so it's important that the board is able to look at situations and make sure that they're implementing decisions that act, for that whole greater interest rather than one individual. So, we talk a lot about the governing documents, the governing structures that are established as a community is formed and what exists within the laws. But then how do we take all of that and implement that? How do we go about the running of business and the delivering of services and expectations to the community at large, right? Because those are words on the paper, but then we have to take them and we have to make sure that we can meet the needs of the community. And really, at an operational level, what this looks like is the inner working between the board of directors, management, and committees, and the owner's role in all of that. And so, probably the most frequent process that comes in front of the board is, there's an issue that's identified. Most of the time that's routed through management. You may be unique in your community where the board may be more visible to the owners. So sometimes those owners are able to reach directly out to a board member and say, hey, I have this concern. I have this question. I have this problem. I have this idea, fill in the blank. It may be one of those things, but something is identified that needs to be evaluated. And the foundation of where we usually start is with the governing documents. Does the community have a responsibility to address that issue? Sometimes it's not always the best served for the community to be the one owning that problem. It could be something that the city may have better ability to affect or impact the outcome of that. It may be a safety issue with police or fire. It may be, an adjacent community that really has the obligation and not your community association. So that evaluation through the governing documents helps to set the knowledge for, is this our problem to act on? Is this our situation to act on? Or is there somebody better suited to solve this problem? And that evaluation then leads ultimately to a recommendation. That can be a recommendation to a board or committee, and then a decision, right? If there's action necessary from a board, that's the key element of this, because our managers aren't making decisions. They're implementing the day-to-day of the decisions that the board is making. So within the process of executing on these expectations, that board decision process is really valuable, because our managers and our team can't really move forward if we don't have direction from the board of directors. And if it's something that there's already a framework on, where you would see this not be necessary for the board decision, would be if there's already a rule or policy or process that the board's established. So, for example, things that function without that decision all the time are going to be things like your collections process. If you've got a collections resolution, if you've got a compliance resolution that says how often you're going to be communicating with owners and what the respective consequences are if they don't take action, those are going to be things that we're implementing once that decision is made. So think about this from a process of the defining sort of SOPs for a community are those rules and resolutions and policies that the board adopts. And that allows our managers to then act on those items and come back to the board if there are ever anything that there's clarity needed on or if something occurs that isn't specifically spelled out. So this is a list that, some of this comes directly out of your governing documents. Some of it comes out of state statute, but it's also a list that is condensed out of our contract. And so within our contract, there's sort of three key sections. There's two main sections that talk about what we're going to do as your management company from a community management perspective and from an accounting perspective. And then there's a section that talks about what the board of directors has an obligation to do. And these are items that are important for the effective flow of work between our team and the board of directors, as well as engagement with your community members. This is sort of a snapshot of if the board is running effectively, then we can run an effective community and management can do their job and the owners can get the decisions that they need and the operations can run smoothly. So within that operational, it's really important that we have a point of contact within the board. And generally, this is the president, not always. But generally, this is the president that acts sort of as that point of contact in between meetings when there are things that we may need clarity on or we may need some guidance on that happens in between a meeting. Generally, these are going to be emergent issues. These aren't going to be sort of one-off, smaller daily operational issues. We really ask that our boards maintain high standards of conduct, right? We all want to work in safe and enjoyable environments where we're respecting each other and making sure that our communication is from a place of respect. Respecting our manager's personal time. It's something that our company takes pretty important and we take very seriously to make sure that our team has time away from the office, time away from their work in order to really show up as the best versions of themselves for our clients. So we're pretty protective of their night and weekend time frames. And if you've been with Aperion for a while, that shouldn't be anything new to you. Board of directors is really tricky in maintaining confidentiality. There's going to be a lot of things that you as a board have access to, accounts receivable records, compliance action. There may be legal matters that come in front of the board, and it's really important that in your role as a board, you ensure that those things are being held confidentially. If you're interested in knowing more about sort of what can be done in executive session versus what can't, I would encourage you to visit our Running Effective Meetings video on our YouTube channel where we talk a bit more about board meetings as well as how to conduct executive sessions and we dive into that confidentiality a little bit more. I also think we have a great training on our YouTube channel with Chris Tingy, who's one of the attorneys from Weil Fotheringham, where we talk about attorney-client privilege as well and what is constituted attorney-client privilege and how to navigate that as being on the board. So we won't do deep dives on any of that today, but there's a lot of other content that's available on our channels if you have those questions. We ask, that you have some kind of basic understanding of Robert's Rules of Order and how to run effective meetings. Not to be a parliamentarian or be rigid in any way, but the use of some basic Robert's Rules of Order. Just make sure that your meetings stay on track and that the process runs smoothly so board members feel like they can contribute, but the decisions are getting moved through and that the meeting is productive. You as an individual board member have an obligation to follow the rules just like your owners. If you've ever received a compliance notice, you know that most of those, we don't drive through a community and discriminate against that. We're going to cite things that we see from our perspective. Um, you are accomplishing one of the things in our contract today by attending this training. So thank you. We do ask in our contract that board members engage in at least annually attending some of our trainings so that we feel like informed board members make a little bit easier board members and ultimately make better decisions when you understand how these processes work. So you have the corporate obligations and then you have the obligations of the individual board. And how does that then translate into the work that gets done? A lot of those obligations that are within your governing documents that are established for the board, most likely you're contracting away. You as an individual board member are not sending out compliance notices or processing deposits unless you're in a self-managed community, then maybe you're doing that yourself. But for the most part, those obligations of the board are then satisfied by you as a board saying, we're going to hire a management company and they're going to take care of these daily things. So then how we come alongside that is supporting those daily operations. Our accounting team is processing your deposits, taking in your money, making sure your vendors are getting paid, taking in any concerns or complaints from your owners and making sure that those are properly getting communicated to your vendors and that maintenance items are getting addressed. We're ensuring that your financial management's getting taken care of. We have a hub where communication is being sent, email communication to your owners, letters to your owners, and then that support for your governance structure, which is enforcing your governing documents and making sure that you're in that regulatory compliance. So all that long list can look a little scary and a little daunting. You might be asking yourself like, hey, when I raised my hand at the annual meeting to be a board member, I didn't realize I was signing up for these things. If you've got a management company, most of those things you're not signing up for. You've chose to say, hey, we're volunteers, we can't do this work. We're going to bring in a management company. They're going to take care of these things for us on a daily basis. And then we're going to be there as oversight and we're going to be there to set the policies, but the day-to-day pieces of things you're not really having to take care of. So then, what's the owner's responsibility in all of this? What are they obligated to do? And part of our role is making sure we're also communicating these pieces to the owner, right? We're spending this time with you today to kind of make sure that you have some fundamental information on how to carry out your role as a board member. We also take, some active engagement in making sure that the owners understand their role, right? When we're sending welcome letters and communication to them, we're making sure they understand, here's how the work flows. Here's who makes decisions. Here's how you reach the right people. And here's your role as an owner. And so, those owners have an obligation to participate in community events. Maybe there's some volunteer opportunities that you guys are doing in your community. They need to participate in the annual meeting. That's really their voice throughout the year, right? They elect a board of directors. Similar to how we elect city council and we elect county commissioners, they're electing a board of directors that are making decisions for that community. And so it's important that they are engaged and participating in that annual process, that they're staying informed. Paying assessments is a really important piece of that. That's how the community keeps services going. You can't pay your vendors. You can't take care of the maintenance responsibilities for a community if you have owners who aren't paying their assessments. And really, we ask the same thing of the owners that we ask of our board members, that we ask of our staff, which is that everybody gets treated with respect. And sometimes in community associations, you can have tense, tense situations that come up, things that are certainly, have conflict or that can cause, strife in a community, but we always really encourage owners to approach those situations from a foundation of respect. It can get tense and uncomfortable, but we always, kind of start from that perspective. So as a board, I've said this a couple of times throughout the presentation, but you are running a business. And how do you go about doing that effectively? And how do you engage with the resources that are afforded to you to make sure that that the owner expectations are met, but you as a board member, your expectations are met as well. And so, really, communication is sort of at the key for a board running effective, right? You're communicating board member to board member. You're probably communicating board to manager. You're probably also doing board out to association. So, a couple things within that framework to keep in mind is when you've got board communication, all of that communication is discoverable. And I think there's just a kind of reality that we've entered several years ago where we have seen an increase in litigation for community associations. So it's important for you to understand as a board that the communication that you send between each other is not protected. So if your board president is communicating to the treasurer, or your board president is communicating to the whole board, and you're talking about something that's occurring in the community, that communication is something that if a dispute arises is something that has to be turned over in that process. So keep in mind when you are navigating the day-to-day of those things, if there are sensitive matters, we always suggest you keep them off of email, out of writing, and if possible, in executive session. If there's written communication that's necessary and it is of a sensitive nature, I would be looping your attorney into that to make sure that that's something that potentially can be protected. Those are always conversations we encourage boards to have with their attorney if there's a situation that has arisen that is, potentially headed in that direction. Your attorney is the best person to give you that advice. But it's important that you have that understanding that board to board communication is discoverable. So be really careful what you put in writing. The other important thing, as I mentioned earlier, the board has an obligation to hold open board meetings. And sometimes this can get a little confusing because, owners want to come and then suddenly participate in that process. So what the state statute says is that you have to have an open board meeting and you have to provide notice of that open board meeting that gives an owner an opportunity to observe the debate and the conversation. The statute doesn't say that the owner has a right to participate in the board meeting. They just get to listen to it. And so when you are engaging in board to board communication via email, this can be seen as a violation of that open meeting. If you're debating something over email and that then doesn't occur in a meeting, then the owners, are not afforded that opportunity to hear that debate. So we do try to restrict email communication between board meetings to really important things. We don't want to be having debate and discussion all the time via email, and then just go into the board meeting and kind of be making those decisions without having that discussion, because that's what your owners have the right to observe. So, keep that in mind when you are communicating with each other between the meetings. We try to keep it to real emergent issues and things that are necessary to have decisions made on, but not everyday conversations, because you kind of get in trouble with these two things. Either it's discoverable or you're violating the open meetings law. And, keeping discussions professional, understanding they're kind of on the record. Those are very tricky things. The association, kind of what we communicate out to your ownership, we try to be consistent in the communication and keep it relevant. We want to be transparent about the information. We're making sure that financials are out there, meeting minutes are out there, governing documents are easily accessible, policies and rules are published when they are adopted. But keep in mind, the association's role in communication is not to sort of serve all of the needs, right? We're not going to be, sending every piece of county communication or every piece of city communication or being like the centralized hub for all things. We're going to allow those individuals to communicate with the owners as necessary, but the goal for the community is to be relevant to the corporation's business at hand and making sure that we're utilizing the tools of the portal and email and newsletters, but not sort of inundating people with communication in a way that they then tune out. So effective meetings, again, we do an entire separate training if you are president or you want kind of a deeper dive on the roles of these meetings, but at a very basic level. Your board meetings are intended to make decisions. They're not meant to be the sort of town hall function between the board and the owners. They're meant to make decisions. So, you'll see that we're setting the agenda in advance. We're making sure that the items that are on the agenda are backed up by issue summaries and backed up by bids or supporting documentation in order for the board to be able to make that decision and set that policy. And so, that agenda is generally set in advance with the board president, and then that agenda leads to our management team establishing your board packet. If there's items on your agenda, you're going to find that supporting documentation in your board packet. And we really want to encourage boards to ask questions beforehand. That allows our management team to kind of come to the meeting with that question prepared to answer, especially if it's something we have to talk to a contractor or a business partner about. Having you read through your board packet ahead of time and get those questions off to the team allows them to be prepared with the answers to that at the board meeting and really allows the board to move decisions along with that information rather than having to circle back after the meeting once they're able to obtain that information. And really, the other kind of process for a meeting is to kind of inform all parties of operational issues. If there's committee updates or maintenance updates or manager updates, those are being given in the meetings. But those are generally informational, foundational to keep the board up to speed on what might be occurring, but those can sometimes not always be things that we need decisions on. So you've heard me mention Robert's Rules of Order. Robert's Rules of Order is a structure of parliamentary procedure that sort of keeps meetings organized. If you are a board president and want any tools or resources on this, we have some great cheat sheets and easy sort of motion guides. But the basics of Robert's Rules of Order is that you are making motions to make decisions. Those motions are seconded. The president's giving an opportunity for debate and discussion, and then you're calling for the vote. And those are all things that get recorded in your corporate documents. So they're the things that are in your minutes that you have an obligation to keep a history of. The other things that you would utilize with Robert's Rules of Order is, sort of the call to order. That's generally done by the president, the adjournment of a meeting. If you have debate that's really continuing on about something and the meeting is sort of stalling, some great tools for Robert's Rules of Order is to be able to call the question, right? That sort of forces your board to decide, is this something that we're prepared to make a decision on, or do we need to move on from this and maybe get some more information about it before we can make a decision? And so some really basic tools can help your board run more effectively. And if you're having long meetings or meetings where maybe not a lot of decisions are being made, check in with your manager. We've got some great tools and tips on structures that can help that, and some resources that we can provide that might help run that a little smoother so that you've got a more effective outcome to that. Executive session, these are closed to your ownership and really are, reserved for a specific subject matter within the statute. So if you are consulting with your attorney, if you've got a personnel matter, if you're taking action against an owner, those are things that can be covered in executive session. You need to go into executive session from a properly called board meeting, which means you need to be in an open meeting. Board makes a motion to go into executive session. You can have discussion and debate in executive session, and then you have to come back into the open meeting in order to make the decision. This can sometimes be a little bit tricky process because you do want to keep the discussion that you had in executive session privileged. And there's a reason that you were doing an executive session, so you don't want to recount all of that when you come back into the open meeting. But you do have to record the motion if there's a decision being made. And your manager can help usually craft that motion or help the board talk through that motion. For example, if you're giving your attorney direction or you had a discussion with your attorney in executive session about strategy, you wouldn't want to come back into that open meeting and have that laid out to the ownership, because usually the person suing the community is a member of the community and they could have access to that. So you may just record a very vague motion that says, the board approves the direction as discussed in executive session for the attorney to proceed, and that can be seconded and voted on and recorded in your minutes. But you don't necessarily have to give direct specifications on here's what we, discussed, decided, and debated. So that there's a really kind of tricky line that you have to dance there, but you have to have a specific reason for going into executive session. Your open meetings are just that. They are the ones that are accessible to owners. Board meetings have to be accessible to the owners, and the annual meetings have to be accessible to owners. And there's a distinction between what business is performed at those meetings. And again, we do some other training on that if those are specific to what you may want to dive into a little bit deeper. Nights and weekends meetings. Again, we schedule these at times when most members can attend, meaning board members, and we try to avoid going into our evening time frames for our staff and our weekends for our staff. There are some very kind of rare occasions where it's necessary, but we try to avoid this when necessary. So, as I mentioned at the beginning, we spend a lot of time talking about obligations and governing documents and legal requirements, and sometimes that can feel a little overwhelming or feel a little scary or daunting to members that are serving on the board. And so we always like to sort of wrap up and provide the foundation of what protects you. So, as I mentioned, one of the Oregon statutes that is applicable to community associations is the Nonprofit Code, which is Chapter 65. And within Chapter 65, this is the verbiage for what protects an individual serving in this capacity. So, you are an unpaid volunteer, and within the framework of the Nonprofit Code, when you are an unpaid volunteer, you have essentially protection that will not be held personally liable for a decision that's made by the corporation unless you are grossly negligent or intentionally carrying out misconduct. And this bar is high in Oregon, I would say. In order to say that somebody is grossly negligent, it's a pretty high bar. You as a board member have an obligation to rely on your experts, and those experts can take a lot of forms. That can be our manager, that could be your attorney, that could be an engineer, it can be a contractor, your landscaper, various different individuals. But you as a board member have an obligation to listen to your experts and then make the decision that you believe is best within the information that they've given you. And even if that decision is an error, sometimes there, are unintended consequences or things that we may not foresee or may not know. You are, as an individual director, are protected from any personal liability on that decision. And the way that we essentially fund that protection is through your directors and officers insurance. And so you have a policy. Every one of our associations has a policy, which is a directors and officers policy. And what that policy's sole intention is to step in and defend you should litigation or a legal matter arise out of a decision that's made by the corporation or the board of directors. And so, association gets sued, you may be named as a director in that. The directors and officers insurance steps in and hires defense counsel that will defend you in that situation. And so it can be inherently, there can be an inherent bit of conflict that comes with serving on a board of directors, but you should take comfort that the Oregon statute and your governing documents protect you as an individual so long as you're acting reasonably. And that's really all that the state asks of you. It's all that your governing documents ask of you. What we ask of you is just to kind of be informed and make reasonable decisions. And sometimes conflict arises from that. We can't always prevent that, but we can make sure that the right framework is in place to protect you as an individual and as a board member. So that is the end of our presentation today. I don't see any questions in the chat, but if there's anything specific that you have, please feel free to unmute yourself at this time. I'm going to stop the recording. Um, and